Good afternoon. I'd like to welcome you all back to the afternoon portion of the 12th Annual Wiley A. Branton Symposium. My name is Najee Thornton, and I currently serve as the managing editor of the Howard Law Journal. Right now, it's my honor and pleasure to introduce the moderator for this current panel, Professor Adam Kurlan. Professor Kurlan received his BA and his JD from UCLA. He's a former assistant United States attorney for the Eastern District of California. And he's been a professor here at Howard University School of Law since 1989. He's the author of numerous books and law review articles that primarily focus on federal criminal law and procedure. And he's also a member of the Criminal Justice Act Indigent Defense Federal Appellate Panel for the DC Circuit, and he's litigated federal criminal appeals in the DC Circuit for the past 25 years. So without further ado, our moderator, Professor Kurlan.
Najee, thank you very much. Well, these are very interesting times to be involved in the criminal justice process, and the topic for the symposium today, the criminal and justice system, is obviously incredibly timely. But it's also coming at a very interesting time. There's been actually some movement in Congress with respect to some long overdue reforms, particularly with respect to trying to do something about the appallingly high incarceration rate in the United States. I don't have the exact statistics, but it's something to the effect that we're 5% of the population. We have 25% of the world's prisoners. And even, I think combined, China and Russia have fewer people incarcerated than we do. And with respect to some of the proposals that are on the Hill that actually might pass, because there's been a political coming together of both liberals and conservatives concerning reducing the time for some nonviolent drug offenders, which is clearly a push in the right direction. It's sort of like finally some pushback from the war on drugs. But even if every nonviolent drug offender was released from the federal system, we would still have an absurdly high incarceration rate. So it's basically just the tip of the iceberg, but it's one thing where there's at least some positive movement. What we're going to hear this afternoon are a variety of other aspects of the current criminal justice system that are crying out for reform in a lot of different ways. So I also wanted, before I actually introduce the panel, and we've got a terrific panel this afternoon, I want to just let everybody know about a couple of things I think everybody who's interested in this topic in criminal justice reform should absolutely read or be aware of. One is an article by Ninth Circuit Judge Alex Kaczynski. I'll give this cite, because I know law students like to write down cites. His article is called Criminal Law 2.0. It's in 44 Georgetown Law Journal Annual Review of Criminal Procedure, and it just came out, so it's got a 2015 cover date. I was fortunate enough to hear Judge Kaczynski yesterday talk. He was on the Hill talking about criminal justice reforms. I believe this article, it perfectly fits into the topics that we're going to hear about this afternoon, but it is a scathing indictment of virtually all aspects of the current criminal justice system. And it starts off with the premise that the exonerations aren't just rare, fluky things, but they reveal a core sick problem with the entire system. And he offers dozens of reforms, recognizing that many of these things are politically impossible to achieve right away. But I'll by-the-line list of a lot of things that we've learned in law school that are sort of like just general assumptions as to how juries operate, whether they follow instructions, whether they can't follow instructions, what the heck does the burden of proof do, issues with respect to so-called experts, particularly with respect to forensic, quote, experts in criminal cases, whether it be tool markings that match up, whether it be fingerprinting, so on and so forth. I believe it is must reading for everybody who is interested in criminal justice reform. And again, that's going to dovetail very nicely with respect to the topics today. Two other quick things. There's a Supreme Court case that is going to be argued on Monday. I don't know if it was mentioned in the morning panel or not. Foster versus Chapman, and it has to do with, it's a Batson case having to do with the supposedly non-racially neutral pretext arguments that are made to kick people off juries. That case is going to be argued on Monday. Again, yesterday, Judge Kaczynski and the lawyer who was arguing the case gave a presentation up on the Hill. So I think everybody should kind of be aware of that case and see what happens there. The one last thing before I introduce the panel is that there's a book I'm reading. I'm about halfway through it. But again, it's another thing that I think everybody interested in these issues should read. It's New York Times bestseller, Ghetto Side by Jill Lavoie. It is a very sobering, truthful account of homicide investigations in South Central Los Angeles. And again, all of these things are intimately related to the issues that we are going to be dealing with this afternoon. Again, if anybody wants, if you didn't write down the site, if you want the actual references, just find me after the panel. Okay, with that, I have the opportunity to introduce, and sitting in the middle is Professor John Acevedo. He's currently a visiting assistant professor at Barry University in Orlando, Florida. He teaches constitutional law and criminal procedure. He previously taught at the University of Southern California and IIT Chicago-Kent College of Law. I went to UCLA, so we're sort of rivals there, but I started my legal career, teaching career at Chicago-Kent, so we've got that in common as well. He's also taught at the University of Chicago. In addition to the above courses, he's taught in the areas of comparative law, legal history, legal systems, American history, theory, and methods. He has a BA from California State University, San Bernardino, and he earned his JD at the University of Southern California. He is going to be talking about restoring community dignity following police misconduct, obviously a very timely topic. At the very far left is Professor Sherry Seidman Diamond. She is the Howard J. Treenans Professor of Law and Professor of Psychology at Northwestern University, where she directs the JD PhD program and is a research professor at the American Bar Association, whose office, I think, is it still right down the street from?
Same building, a key card away, very convenient.
Key card away, yeah, and a gorgeous part of Chicago, if I might add. She's an attorney and social psychologist. She's one of the foremost empirical researchers on jury process and legal decision-making, including the use of science by the courts. She's published more than 100 articles on legal decision-making in law reviews and behavioral science journals, and she is currently completing a book on juries based on unique field experiment in which cameras recorded real jury deliberations. That in and of itself is sort of a fascinating, almost taboo topic that is shrouded with kind of almost like religious mystery as to you can't know really what's going on in the jury system, in the jury box. By the way, that's the other reason why professors always want to be on juries. I've tried to get on a jury for years. I always get kicked off for one reason or another, but it's because if you're on one jury, just think of all of the lessons, not stories, lessons that I would be able to tell for years and years and years about the inner workings, whether it's a one-day, shoplifting case, but it'll be interesting to see if when the recordings. Okay, she's going to talk about race and jury selection and the pernicious effect of backstrikes. I take it you're pretty well up on the case that's going to be argued Monday as well?
A little bit, yeah.
Okay, interesting. Okay, our last panelist is Joshua Kaiser. He is a law and social science fellow at the American Bar Foundation and a JD PhD candidate in law and sociology at Northwestern University. His research focuses on understanding crime by analyzing how criminal law is created, defined, and implemented across various contexts. In the United States, he researches federal and state government's role in creating and controlling criminal behavior through the law, specifically through hidden sentences, meaning all deprivation or harms imposed by law as a direct result of the criminal status that are implemented by processes external to the criminal law or decision maker other than a sentencing judge, and through two, racial bias in jury selection. And he's going to talk on the production of a hidden penal system, courts, the collateral consequences movement, and American ideas of punishment. And if I understand it, that's actually a co-authored piece between, do I have it right?
No, it's the
Oh, it's the other way around. The first one is, okay, in any event. Okay, I have spoken long enough. With that, I am going to turn it over to, let me get my order back. I'm going to turn it over to Professor Acevedo.
Thank you so much. Thank you for having me here. It's a wonderful symposium, and I'm very excited to be part of it. My research really started at the Law and Society Association conference as a dinner conversation about the idea of dignity takings in South Africa. And as it was described to me, it's when the state, for not a good reason, destroys or confiscates property from owners or occupiers who it deems to be sub-persons without serving a legitimate public purpose. And as this was described to me, it occurred to me that this is really what's going on with police brutality. In all of these incidents, it's something more than the basic money that's lost, than the physical abuse. It's the taking of the individual and the community's dignity. And therefore, our remedies must address that as well. As I was writing this paper, news events seemed to unfold over the summer, causing me to alter it and incorporate. So the first of these was Eric Garner's family with the large award saying, this is insufficient. This is not enough. This does not make us whole. We've lost a loved one. Our loved one's been demeaned by the police. Money will not suffice. And that's what I want to address is what will suffice? What can make a community whole? And I think it's necessary because until you do that, until South Africa began to do that, you can't begin the healing process. You can't begin to reintegrate the community that's been targeted or communities that have been targeted by the police back into the state, into a meaningful relationship. So I looked at the existing remedies we have, which are essentially threefold. We've already heard of one, the Department of Justice remedies, which really are to prevent future police misconduct. And again, that's necessary, that's essential. We want that to happen. We want more training. We want integration of our police forces, but that doesn't help the victims. Again, tort remedies, if we look to Ferguson, yes, it can help for the major cases, for the Rodney King, for Eric Garner, but for all the thousands of other people who have suffered at the hands of police with prolonged stops, with unjust stops, with being targeted because of the color of their skin, for being pulled over to receive tickets. And yes, they were violating the law, which makes the tort system unlikely to work for these people. I mean, can you imagine a jury actually awarding damages to someone who did indeed violate a law, even if it's a petty law like failing to turn on your signal? But yet they were targeted. There is a harm here, and theoretically, yes, you can bring a suit for the misapplication of law, but I think it's unrealistic that people are going to, one, be able to bring and win these suits, and that's going to cover enough people. I know you could do class action, but it still feels insufficient because even let's say you win, all you get is money, and that's not enough. You were still degraded on the side of the road, as many of the Department of Justice investigations have found. People pulled over for no reason other than who they are, and made to sit on the side of the road for 2-3 hours, and then told, okay, we're moving the handcuffs, get in your car, go. There's no ticket, there's no record even. And how to then get these people some form of remedy. The third remedy is, of course, the prosecution of police, something we're going to hear about, something that is essential in the most egregious cases. But again, in the most egregious cases, in the average case, it's unlikely to happen. Rare is the district attorney who's going to put their career on the line. And those that do, we need to applaud. We need to encourage them. But it's a rare thing. So what do I suggest? I looked at this, and I started with the Department of Justice investigative reports. There's not been many. There's been about 33 at this point since the passing of the law following the Rodney King incident. That comes out to about 3 a year. That's not terribly great. In addition, we can look at the cities have developed tremendous ways to drag these out. Chicago famously has dragged out The Berger case, the Midnight Squad who went around actually torturing people into confessions, they dragged that case out for 15, 20 years. They were able to slowly delay the Department of Justice and the tort suit that went along with it. Police departments have become very adept at this, like any large corporation is, burying people in the process. So what I look at are two things that were done in South Africa following apartheid, and there it was more dramatic. It was the taking of land, but here it is the new Jim Crow. It is the same idea. It's creating an underclass of citizens, and those people need to be brought back in to society at whole, reintegrated into it. So I look at one is the idea of, excuse me, the idea of a Truth and Reconciliation Commission, and the second is community reparations. And here Chicago is actually a great example. But first, Truth and Reconciliation Commissions. First thing to note, this is not just your civilian review board. That, again, is a prophylactic. That is something that is hovering over the police. This is in response to these dramatic incidents, in response to Ferguson, Baltimore, Chicago multiple times. Chicago yet again seems to be having another issue despite being under a Department of Justice investigation and even Department of Justice orders at this point for collection of data. So this instead would be, again, following more along the lines of South Africa, a one instance after the incidents have come to light to give the community an opportunity to have their voices heard. And in that sense, it is a procedural fix to go off our keynote speaker. It is the idea that people need to have their voices heard, and that's part of the healing process. Again, we could also extend it to having the police heard. And in exchange for this, granting them some form of financial immunity. It sounds radical, but when we think about it, most police are indemnified anyway, and we don't really want to reach them. We want to reach the city. That's the level of change. The individual officer, obviously, the reprehensible ones need to be prosecuted, but for your average officer who has seen the systematic abuse, possibly even engaged in it, to give them a forum also to speak. There are some good officers out there who do want to reform the departments. They want to have an honorable living, and we need to help those officers improve their own department. And that's the key. And that's the other focus of this is quite often it is an us versus them mentality, and we need to break it down from both sides. We need the police to see that they're part of the community. They are not separate from the community, and there so often are. They are so often removed, and it's the people we need to control. And I think this is one opportunity where we can start breaking that down. There is precedent. Greensboro, South Carolina, attempted a Truth and Reconciliation Commission in 1999. It wrapped up, I believe, in 2004, and this was to address the long systemic intertwinement of city government with the Ku Klux Klan. And this, they did exactly that. They gave city officials some level of immunity, not full, but some level. Again, it would have to be a case-by-case basis. We'd have to look at each city and the culpability factors, and they actually were able to come out with some new ideas. People were able to vent their frustrations over, since the 70s, since the labor disputes that they had back in the 70s, all the way to 99. Some of it was like Department of Justice, it was training, but some of it was erecting a monument to those persons who had been persecuted by city officials. It was ensuring that it was commemorated in the town in some way on, I believe in their case they did it on Martin Luther King Day. This then leads us to our second idea, community reparations. Here, Chicago is actually a great model. Just this summer, Chicago, again, in response to the Midnight Crew, created rather far-reaching reparations for the community. Everyone who was a victim got a cash award, not a large cash award for what was done to them, but $100,000, somewhere lower at 30. But on top of that, them and their family members were given access to free counseling. In addition, they and their children and their spouses were given free access to the Chicago City colleges for an education to improve their lives. On top of that, again, a monument is going to be erected commemorating the victims of the Chicago PD's violence during this era. They're going to also require that this be taught in schools in the city of Chicago, in curriculum. I don't have it written down. I believe it's in grades 6, 8, and 10, if I have that right. It might actually be 5, 8, and 9, but 3 times elementary, middle, and high school, that they'll repeat the story so it isn't forgotten. And in this way, it's more than a simple fix. It's more than, here's some money, now go away. It is, let's engage the entire community in this. We're going to commemorate this as something that was done, so we remember it and don't repeat it, hopefully. Again, Chicago, unfortunately, seems to be right back in that same spot, but the hope is that if enough departments do this, we might then be able to reintegrate communities. The other thing here is this idea of dignity. This idea that we all have human dignity has, for good or ill, re-entered finally, and I think it's for good myself, the actual jurisprudence of the United States in Obergefell. Again, I had not expected that decision to hinge on dignity so much, but Justice Kennedy made it a centerpiece. That actually caused me to rewrite the first part of this paper after it was done. I had written part of it, that decision came down, but the idea that dignity needs to be protected by the laws of the United States, that it is something that we are going to recognize, it's something that's of value, that can be harmed, that can be taken. I think that speaks to a change in the perception of law that we need to harness at this moment. We need to take this idea and start looking for remedies to make sure that these communities that have been targeted for years by the police are now reintegrated into it. The Black Lives Matter movement is harnessing this. This is exactly what they're going for, that we matter, our lives matter. So we should now look for legal ways to instill that in our system, to make it part of the legal regime, rather than simply an occasional tort suit, an occasional prosecution, but instead, when these incidents come up, trying to bring the community immediately in to contact with the state, with the city, again, to show that we value the experiences of these people, that we believe them, that this did happen, and that we are going to redress it, rather than simply paying the few squeaky wheels and shoving everyone else under the rug, but instead saying, no, we're going to give all of you a remedy. We're going to make sure that this is remembered, that we try not to do this again. And I think I'll stop there and turn it over.
Okay, next up, Mr. Kaiser?
Well, thanks very much for having me.
We'll take questions at the end, so I suspect that we'll have plenty of time for all that.
Well, thanks very much for having me. Prisons. That's what we think about when we think of criminal punishment. Prisons, mass imprisonment, and the death penalty. Sometimes we remember to think about probation. Sometimes, parole, release from prisons. Sometimes we remember that everybody also gets a fine if you're processed through the criminal justice system. But what we rarely think of nowadays, and what almost nobody seemed to remember 5, even 10 years ago, was that there's a whole host of additional penalties, thousands of penalties. Felons in 51 jurisdictions can't vote. There are literally thousands of jobs that you can't get if you're different types of criminal offenders. You can be barred from being an attorney, lawyer, doctor, but also things like barbers, garbage collectors, civil servants. North Dakota, there are 2 laws that ban, depending on your offense, you can be banned from dealing wool or beekeeping. And I couldn't actually make these up. They're incredibly far-reaching. And then there's restrictions on welfare rights. If you're a drug offender across the country, you can't live in public housing. You have trouble getting food stamps. You can have Social Security denied to you. You can lose your retirement benefits that you already have. There are other political rights that are denied. You can't sit on juries. There's a limit on the number of lawsuits you can bring, or the types of lawsuits you can bring. I could go on. There's literally 35,000 laws across the country, 32,000 laws across the country that impose more than 45,000 penalties. I call these laws hidden sentences. The definition I'll give you is any adverse restriction or requirement, any punishment, imposed as a direct result of criminalized status of some kind. Could be conviction, could be imprisonment, it could be just having a criminal record. Just being arrested can make you subject to thousands of penalties. And these are any punishments imposed by law as a result of criminal status, except those that are imposed either by the court of conviction or a criminal law process of some kind. Some of you may have heard these called collateral consequences of criminal conviction. Same idea. The term's wrong, though. These are punishments. The only difference between these punishments, imprisonment, parole, probation, death, fine, the only difference is that we remember that those are punishments, and we forget that these exist. Even those of us who know a lot about this tend to forget that they're important and when they're important. And so I could take this subject and go any number of ways. I could sit here and talk probably for hours about the history of hidden sentences, where they came from, how they became hidden. I could talk about the effects they have statewide, the distribution, the effects by race, by poverty. What I'm going to focus on today, even though I'm happy to answer questions, is the causes of hiddenness. Why is it that routinely throughout history that somebody brings these laws up and then everybody forgets? Why is it that criminal offenders go through this process multiple times and yet we have no collective knowledge on hidden sentences, on this body of law? How is it that we go through law school and a lot of the time nobody even mentions a collateral consequence or hidden sentence? You certainly don't hear about it in basic criminal law, unless things have changed in the last 2 years. So I want to give you 2 examples from history. So first, let's go back to the 1950s, solidly in the rehabilitative era. The criminal justice system was focusing on treatment, on rehabilitation. There were experts involved. There was research involved. And the goals were reform, right? You go through the system, you come out reformed, a new person ready to re-enter society. There's a little bit about recidivism that we focus on now, but it was more of a holistic movement, right? That's what the prison was for. And in the middle of this, in 1955, the National Council on Crime and Delinquency passed its Standard Probation and Parole Act, passed it every year. And the 1955 one proposed that an offender's civil rights should be restored upon completion of his criminal sentence. Proposed that hidden sentences should be removed at the completion of your sentence. A year later, the National Conference on Parole came to a similar conclusion that civil deprivations of ex-offenders were, quote, an archaic behavior, a holdover from earlier retributive times. By '67, the issue made it to the White House. The President's Crime Commission noted that, quote, there had been little effort to evaluate the whole system of disabilities and disqualifications. Little consideration has been given to the need for particular deprivations in particular cases. So in other words, there are blanket punishments on, say, all felons. All felons would have trouble getting a driver's license, rather than felons convicted of driving offenses. And as a result, in 1970, a comprehensive study on collateral consequences was done at Vanderbilt Law School as a special project for the Law Review. There were hundreds of pages written on this body of law and multiple avenues of recommended reform. In '73, the National Advisory Commission on Corrections recommended fundamental changes in voter disqualification. And then, in '81, the American Bar Association promulgated the Standards on Civil Disabilities. Any law student heard of the Standards on Civil Disabilities? Sound familiar? It's because it disappeared. But the standards, the ABA came out and recommended that no civil disability be automatically imposed except those related to the offense. For example, revoking a driver's license for a driver's offense, right? That disabilities be imposed on a case-by-case basis upon determination that it was, quote, necessary to advance an important governmental or public interest. And third, that they be imposed only for a limited time so that there is adequate avenues for relief. Besides, you can always be relieved from hidden sentences by having your record expunged and given a pardon nowadays. You need both to really avoid all of them. And so the ABA recommended that we come up with a easier procedure. And yet, this was the end of that collateral consequences movement. No progress was really made. The movement never reached public prominence in 30 years. It was known in select criminal justice circles. And only a few hidden sentence laws were actually repealed or amended, while more continue to be created. Why? So the reason I'll focus on today is the framing of the movement, the idea of collateral consequences. The term itself was born around the Vietnam War. It was focused on collateral damage against civilians as a way of critiquing military action, and it fit perfectly with the overall frame of the collateral consequences movement here at home, to criticize how well prisons reform and rehabilitate offenders. It focused on the rehabilitative move of prisons, not on collateral consequences in their own right. So the problem was successful integration into communities upon release, right? Not collateral consequences themselves. And every single aspect of the movement approached hidden sentences this way, and not as overbroad or unfair punishments, but rather as a problem for the effectiveness of correctional treatment and rehabilitation. So, for instance, the 1956 National Conference on Parole I mentioned concluded that the present law on deprivation of civil rights of offenders is unjust because it's in contradiction to the principles of correctional treatment. The National Advisory Commission in '73 went for voter disqualification reform because it's necessary to, quote, reintegrate the offender. And the ABA standards themselves were focused entirely on reintegration after prison. And so these goals ought to sound familiar. Today we have the reentry reform movement. It's born again, and it's got the same sorts of goals. It focuses on hidden sentences as collateral damage of mass imprisonment. It's another way of criticizing what mass imprisonment has done to our society, and it's right from that respect. But the story here I'm telling is so important because if incarceration rates dip, if the prison reform movement is successful, the reentry reform movement has very little left to do with the way it's currently focused. So by the time the ABA standards came out in '81, the punitive turn in criminal justice had already happened. It was the last time that the left and the right got together and agreed that something is wrong with the criminal justice system, and rehabilitation was abandoned as a failed model. And since the collateral consequences movement focused only on collateral consequences as a problem for rehabilitation, it was forgotten, and hiddenness returned. So, before I conclude, I want to get to a second part of this story. So, during the same period, almost coincidentally, this failed political framing was accompanied by a new legal rule called the collateral consequences rule. It should be an important rule in constitutional criminal procedure, but we don't even really hear about it in there. The rule is that the Sixth Amendment duty of an attorney to give effective counsel and or the Fifth Amendment duty of a judge to inform a criminal defendant of the possible consequences of conviction. Neither of those duties require the judge or the attorney to inform the defendant of collateral consequences or hidden sentences. Neither party is responsible for it. As a matter of fact, nobody is. Nobody's responsible for informing an offender that hidden sentences exist. Instead, judges and lawyers are only responsible for providing notice of the, quote, direct consequences of conviction. The earliest iteration of this rule came about in 1954 in United States v. Perino. If law students want to write down cases, I can give you citations later. It's a Second Circuit case. It addressed the question of whether a guilty plea could be invalidated because the attorney wrongfully told the defendant that he couldn't be deported if he pled to this crime. And the court ruled that collateral consequences were exempt from the notice requirements for two reasons. First reason, there was no precedent otherwise. Which right, there's no precedent otherwise, therefore I must do this. Just doesn't, it actually means therefore you can choose either way that logic and jurisprudence bring you. And so the second reason, the one that you would hope to be a nice, sound jurisprudential reason, was one sentence. It seems palpably unsound to make the attorney inform the defendant. Palpably unsound. That was the case. And that's where the rule came from. And the rule spread kind of slowly over the next 2 decades across the other federal circuits. The Fifth Circuit, the Seventh Circuit, Ninth and Tenth, all simply asserted with no analysis, not even palpably unsound, no analysis whatsoever that there is no such duty. And the DC Circuit said the same thing. There's no lack of precedent, therefore collateral consequences require no notice. I'm sorry, there is lack of precedent. So the first actual analysis of the rule was in 1963. Third Circuit case called United States v. Cariola, I assume is how you pronounce it. It starts with C. The defendant considered that the majority considered the practical impacts of the rule on the judge and on prison populations of deciding that courts should have the duty to inform criminal defendants that hidden sentences exist. Remember, we're not talking about a court sitting there and reading 35,000 laws. We're just trying to get as far as somebody tell me this body of law exists. And the court focused on the problem that neither criminal defense attorneys nor criminal law judges are experts in hidden sentences because they tend to appear in civil law rather than criminal law. And because they're not experts in it, it would be very difficult to give them a duty to inform the defendants. And so the court ruled the same as the other circuits did, that there is no such duty. Now, what I want to point out here before I close are a couple of severe logical flaws that some of you probably already put your fingers on. So just because judges and attorneys don't have the knowledge of a body of law doesn't mean a criminal defendant doesn't have the right to be informed of it, right? There's a logical disconnect there. It might create a practical problem that then we'd have to solve, but it doesn't logically connect. And just because the convicting judge doesn't have direct discretion over a penalty, which is often true for hidden sentences, doesn't mean it's not a penalty or a punishment. There's a whole other set of Supreme Court jurisprudence that exempts hidden sentences from punishment requirements, such as double jeopardy. So, in short, for a constitutional issue, there's an interesting lack of real constitutional analysis or principle at all. And what this rule does is it assures that hidden sentences remain hidden. It still exists. The Supreme Court has yet to really rule on the issue. All but 2 circuits have agreed. The other 2 circuits remain silent. I think 37 states have adopted the collateral consequences rule. This is the law of the land. And so let me close with a warning, because I'm running out of time. And you can take it as a warning or maybe a push for further action. We're in this great moment of reform. Maybe, hopefully, the end of mass incarceration, right? But what will be left? If we end prisons today, abolish them, what happens? Does everybody end up on probation, parole? What happens to these 35,000 hidden sentences? Most of them don't depend on you being in prison. Some do. So maybe 2,000 would be my best guess. That leaves 30,000 penalties. And offenders will still have no knowledge of those penalties when they run into them. They'll have no warning what they are. And because there's no law that requires them to receive systematic notice. And without a focus on hidden sentences as punishments themselves, the reentry reform movement isn't likely to change this situation. Rather, we're focusing on hidden sentences or collateral consequences as an obstacle for reintegration, which they are, but they're also punishments in their own right. They are part of the penal system we have, the hidden side of the penal system. And imprisonment affects about 1 in 30 American adults at any given time. If you lump prisons, probation, jails together, you get about 1 out of 30 American adults. About 1 out of 3 American adults have a criminal record. About 1 out of 3 American adults are affected by hidden sentences. And so our work here isn't done. I'll leave it with that.
Mr. Cass, can I ask you one quick question before?
Sure.
And right now, my mind is a blur with all these Supreme Court cases going on and everything
Yeah.
else that's happening. Didn't the court at least deal a couple years ago with the Sixth
deportation?
Amendment? Yeah, the deportation, saying that it's at least it's ineffective assistance of counsel if you don't.
It did, and I'm glad you brought that up. The case was Padilla v. Kentucky. What the court did, though, is it sidestepped the entire rule and said deportation is an exception. So we don't have to address the rule itself. We're not going to say whether the rule stands or not. But attorneys do have to inform defendants of possible deportation.
If upon a conviction.
Right, right. And so it's a step,
Okay.
but a small one.
Everything is small steps. No.
Hey, small steps are steps. I'm not complaining too much about it.
All right.
Thank you.
Professor Seidman-Diamond, you are next.
Okay, thank you. Well, maybe this is about small steps, too. I think that's probably right. So first of all, I want to say thank you for allowing me to come here. I enjoyed the morning so much, and it's great to be a part of this. We've been very well taken care of by Ms. Perez, and I actually seriously considered just turning the podium over to Felicia because she did such a great job at lunch that I just thought, well, I'll give her my time for a little bit more talk. She's probably got all kinds of interesting things to say, but then I would be shirking my duty. So the advantage of being here is I get to talk to you as well. We were asked to say something personal about ourselves, which I think the morning panel did. I just thought that I would mention a couple of things about Northwestern, which is where I am, because I've had the opportunity to work at Northwestern with some of the people in the clinics, and in particular, we have the MacArthur Center for Justice located at Northwestern. And through the years, I've done a couple of projects with them, one on the death penalty, one on bail hearings. And then so when they came to me and said, well, would you look at peremptory challenges in Louisiana, I said, yeah. Because the first study I ever did was actually on peremptory challenges. So it seems as if I'm kind of coming full circle, but with a little tweak on it, and I hope we'll talk about that in the question and answer. So I thought that I would begin. This is supposed to work. We may, look. Isn't it amazing? Okay, so Josh and I have this paper. You are the first to have a look at it, and it is on backstrikes. And before I get to a little bit of history, does anybody know what a backstrike is? Oh, great. That's terrific. So you'll learn something new just by that. Okay. So I thought I would go through a little bit of history on jury selection before I get to backstrikes and set up the analysis that we did on the data from Caddo Parish. This is the 800th anniversary of the Magna Carta. And the Magna Carta gets kind of taken for things that it isn't really. And so I thought we would just look at the language from the Magna Carta. And you'll notice the language that refers to peers. You know, you can't have any, you can't be imprisoned without lawful judgment of his peers. Now, you also know from your courses that peers doesn't appear in the Constitution, which is probably right, because what the Magna Carta meant with respect to peers is that a nobleman could not be tried by the commoners, but had to be tried by fellow noblemen. So it's not exactly what we have in mind when we think about the jury. Over time, things have changed a bit, and of course, the provision in the Constitution in the Sixth Amendment refers to an impartial jury. Now, it wasn't quite clear what an impartial jury meant, and probably still isn't completely at this point. But for a long time, there was a key man system. So what you would have is white male jurors, I mentioned the male part too, over 21, who would be selected, reputed to be honest, intelligent, and esteemed for integrity, good character, and sound judgment, i.e. the jury commissioners picked their friends and people that they thought would do a good job. Now, over time, the Supreme Court has interpreted to some extent that impartial means a fair cross-section. So we've added a little bit of meat to it, but not completely, as you will see. So the slow expansion of jury pools, it's hard to believe, perhaps, that in 1880, it was still the case that there were state laws on the books and used in which whites were the only eligible members of the jury pool. So West Virginia had a statute that explicitly excluded minorities, And it had to go to the Supreme Court for the court to say that that was unconstitutional under equal protection of the 14th Amendment. So that was in 1880, but it wasn't until 1968 that Congress passed a law specifically indicating that the jury pool had to be drawn from a fair cross-section of the community. Now, the jury pool is different from the jury, and that's a distinction that we see in the history that goes from that point. So it's one thing to talk about drawing a cross-section of the community by sending out qualification questionnaires and summonses, and something quite different to talk about the actual makeup of the jury. So it's been a long, hard move from that. In Swain versus Alabama, we have in 1965, this is before the federal law, a long opinion which talks about the great virtues of peremptory challenge and how it's been around from 1790, and explicitly says, well, you know, the key man system is exactly fine in drawing from the jury pool. And oh, by the way, when things get to the courtroom, it's up to the attorneys to decide who to remove on any basis at all. And that includes race and gender, and that includes any other characteristic you can imagine. That's what a peremptory challenge is. Well, we do get some improvement, and by 1986, the Batson case, the Batson versus Kentucky case sets up a very elaborate structure for raising questions about whether race was involved in the exercise of a peremptory. Some of the justices on the Supreme Court were skeptical that it was going to have an effect. Over time after Batson, there was an expansion so that by the time we get to Powers, we find that everybody has a right to challenge a race-based exercise of a challenge. And that is true no matter what the makeup of the jury is, no matter what the race of the defendant is. It's applicable in civil cases as well. It becomes a jury right to not be discriminated against, as well as a defendant right. So you might think this is great expansion, this is terrific. But it turns out that it is very hard to make a convincing case that the challenge is race-based. And there have been a whole series of cases that have gone up. There's one, as you were saying, that's going to be before the court in oral argument on Monday. Unless the prosecutors, usually prosecutors, are very inept and document in a serious way the basis used in race, it is very hard to make the case. There have been some cases where it has been successful, but they are relatively limited. So we get to the backstrike. And the backstrike exists in Louisiana, Florida, Tennessee, and a little bit in Illinois, although it's a kind of modified version. What the backstrike does is it allows an attorney to initially accept a juror and then change your mind later, as long as it's done before the jury is impaneled. So you can tentatively accept a juror, and then after you've done a little bit more jury selection, you can go back and strike that juror. And we have seen that it can be used in a kind of nefarious way. The case that went to the Supreme Court was Snyder versus Louisiana. And in it, Mr. Brooks, who was a college student, was a little hesitant about whether he could miss his student teaching, but he was accepted by the prosecution, who then used challenges for 2 other black jurors. The ultimate effect was he went back and challenged Mr. Brooks before the jury was impaneled, and it ended up with an all-white jury. And one of the courts on appeal suggested that this was a strategy for being able to go back and visit and not get a Batson challenge on the other 2 juries. So we have the first systematic study that looks at the patterns and behavior of attorneys in Cato Parish, 332 cases, to see how back strikes are used in the jury. And so just to give you an overview, and then I'll turn it over to Josh, who will give you more details of our analysis. The overview is prosecutors exercised back strikes in 30% of the cases. So this is not a rare event where you have a back strike. In addition, prosecutors are more likely than defense attorneys to exercise back strikes. And lo and behold, prosecutors are 3 times as likely to strike a black juror using a back strike than to use a back strike on a white juror, non-black juror. And we wanted to control for a variety of things, and Josh is going to describe that analysis.
Thanks. So, there could be multiple other factors that describe the patterns we just saw, right? So those are just the blanket patterns. You look at the pattern of cases we're looking at, and 3 times the prosecutor struck 3 times, or black jurors at 3 times the rate as the prosecutor struck non-black jurors. And the cases, the prospective jurors are mostly white and black, but there is a small group of other races involved. And so what I mean by there could be other factors. Take, for instance, maybe black jurors show up more frequently on cases that take place in a shorter amount of time because black jurors are more likely to receive a hardship exception for long cases because black jurors are more likely to be poor jurors as well. You could see that kind of connection there. And then maybe shorter cases tend to be cases with 6-person juries rather than 12-person juries. And so you can see one of the controls listed up there is a 6-person jury, or the size of the jury. We also control for the cases themselves, and in statistical terms this is a cluster effect, but basically every single case could have its own particulars. And so we control for, say, the prospective jurors within each case. We also control for the number of defendants. This is really key because the number of defendants determines the number of strikes that both the defendant and the prosecutor have. So if there's a 12-person jury, there's going to be 15 jurors, 12 jurors and 3 alternates, and the prosecutor will have 12 strikes per defendant, and the defendant's attorney will have 12 strikes per defendant. So if there's 3 defendants, you can see that there can be a lot of strikes in these cases. And the veneer size will be much larger for these because they'll go through a lot more prospective jurors, or they can. Yes? Oh. Sorry, hopefully you all can hear me a little bit better if I pull the mic closer. We're also controlling whether the case is involved an identifiable victim. Maybe prosecutors and defense attorneys behave differently if there's a victim for the jury to identify with. We control for whether the, I got 12 members. We control for the proportion of the jury size to the proportion of the proportion of the jury size to the venire size. In other words, if there's 15, let's say 20 prospective jurors come up before a case, 3 of them are excused for cause. It's a 12-person jury. So there's going to be 17 people that could sit on this jury. It means their chances of being struck are much higher than, or are much lower than if there were 170 people that were going to sit on a 12-person jury. And you have to go through a lot more prospective jurors that way. And even if the process was completely random, you'd expect this proportion to matter. And then, of course, we control for the proportion of black and male jurors in the effective venire. When the prosecutor is looking at a prospective juror and thinking, okay, so I'm trying to construct an all-white jury, or at least put as many white people in this jury as I possibly can. But I'm looking out here at all the jurors that are the prospective jurors that are about to come before this panel, and they're all black. So why would I waste a peremptory challenge trying to get rid of a black juror here and make it look like I'm just striking because of race? And so you have to control for in theory, what the prosecutor is looking at. And this may or may not be as important for backstrikes. When we're talking about peremptory challenges, generally that might matter. When we're talking about backstrikes, it might not, because you can strike much later in the process. There can be, if you're not familiar with the process, jurors are impaneled, say 12 at a time. And 3 panels later, you can still backstrike somebody that you accepted 3 panels ago. So, and then we control for the race and gender of the judge, the race and gender of the prosecutor. See if that makes a difference. Maybe black prosecutors are less likely to have racial bias in their strikes. Maybe not, but it's an important question to ask. And so, what turns out after we run the analysis here, the significant predictor of a prosecutor's backstrike, there's only 3. The number of the defendants on a case, which means the number of strikes that are there, which you can imagine just kind of makes the likelihood of a backstrike taking place at all higher. The proportion of the jury size to the venire size that I talked about, which I told you would be important regardless of whether it's random or not, and then race. The odds of being struck are 3.33 times higher for a black juror than a white juror. That means if you sit on the panel with a prosecutor that has, and you're a white juror, and the prosecutor has about a 10% chance of striking you. If you're the exact same person but black, it's a 1/3 chance of being struck. That's what our results show here, of being backstruck, excuse me. And so the bottom line is that backstrikes over and beyond other features of jury selection impair race-neutral jury selection. And so I think I already harped on the 3 times more likely. Batson challenges are going to be much more difficult because of what we heard in Snyder. So a prosecutor in Snyder went past struck 2 black jurors, but had accepted the first black juror. Then waited overnight, the next day came back and backstruck this first black juror, Mr. Brooks. And what the prosecutor more or less said is that it took him all night to come up with a reason for it. And so you can imagine, but in the meantime, the defense attorney didn't bring a Batson challenge because of the 3 prospective jurors that came up that were black. 1 was accepted and 2 weren't. It didn't really look like a pattern of racially biased challenging until the backstrike came up. And backstrikes may be particularly bad in, say, Louisiana or other cases or other states where you only need 10 people on a 12-person jury to convict. You don't have to have all 12. And so if you're trying to create, say, an all-white verdict, you don't need an all-white jury for it. You just need 10 out of 12. And backstrikes can make this even worse. So at the risk of repeating myself twice in 2 different presentations, we're not done yet. We have more to do. Decarceration is great, but I think actually all 3 of these presentations have shown that there's a lot more to do in reforming criminal justice. And I'll shut up and take questions. Thank you.
All right, thank you. We'll take questions in a second, and if you want to ask some questions, line up on, is that mic there, or you want to, so just line up on both sides, and then we'll just alternate. I'm going to take the moderated prerogative and ask one quick question, and then one not so quick question. Again, with respect to the backstrikes, though, backstrikes are peremptories, though.
Yeah,
Correct? So if you used up all of your peremptories before you got to backstrikes, you could not do it.
Right.
Yeah, remember that in Louisiana, we're talking about the highest number of peremptories available in almost any state, with 12 on each side and 12 per defendant on each side. So the odds of using up all of your peremptories are smaller in that situation.
Right. One other question, and it wasn't formally covered in the presentation, but I'm just kind of curious. Most of the most legitimate polls show these days that with respect to African Americans, 1 in 10 believe the criminal justice system is fair toward minorities. And if you ask whites that same question, they say 6 in 10. And I'm just wondering, and I'd just be curious if, whatever you guys have to say about that, with those numbers, how do you square the ability to use that information with respect to a Batson challenge? Because I don't think Batson ever perceived that there was going to be such a significant difference with respect to a particular race's view of the fairness of the criminal justice process. And I can see why a prosecutor, knowing those statistics, would care about the race of the particular jurors. Just a thought, and then I'm going to sit down then and not talk anymore.
Did you want an answer? Or?
Well, no. I'm just curious as to if you guys have a comment on that. If not, I want long lines of people streaming to.
Yeah, I mean, I have something to say about that because, it may be true that there's that correlational relationship, and it may be true that the prosecutor is tempted. It just happens to be unconstitutional at this point to use that information. But it does have implications for something else, which is really important, and that is that what I worry about that attitude and what we see in some of the data is that African Americans are less likely to be willing to show up at court. And if that is the case, because they don't think the system is fair, because they don't think that they will be selected, if people don't show up, then that means that the jury has fewer options to be fair as well. And I do have one final table that I'd like to show you, if I can.
Yeah, it's a.
Oh, it's great. So this is the actual distribution, the makeup of the jury veneer. And you can see on the far left that the veneer is 36% black in Cato County. The selected jurors are not as representative, but it's not quite as far off as you might expect. And it's in part because the prosecutors are much more likely to challenge and remove blacks, and the defense does some balancing on that, and they do have the effect of counterbalancing each other. The more interesting thing is not in this table, and that is that the percentage of blacks in the veneer is much below what the eligible jury population is. We've seen this here in Cato County. There's a study on it in Florida. There's a study on it in another jurisdiction, so that even with some degree of balancing out once people get to court, if people don't show up to court, you're getting you're getting disproportionately low percentages of blacks in the jury pool. And I think that's the important thing. I'm working with the chief in the Northern District of Illinois to see what we can do to increase response rates, because that's really where the action is, I think, where a lot of the action is.
Okay. I've got dozens of questions for everybody, but I'm not going to ask them. It is time. We have about 15 minutes of questioning, so go to it.
That's all. Thank you, sir. Thank you all for being here. Thank you, Professor Curlin, for moderating. I'm one of those people who don't entirely believe in the system because of the information that was presented this morning and the stats that we see here this afternoon. So, in your opinion, how would you go about restoring faith in the community, people who have been impressed by this very system?
I feel like I've been talking too much.
Sure. I'll start then. I think it's every level. I mean, I think the panelists this morning hit it on the head. It's at every step. There are just some parts we're not going to be able to change. There's going to always be discretion in the system, and it's going to be abused. So the trick is going to be to find ways to minimize that. It's going to be find ways to, again, as I firmly believe, reintegrate the people who have been oppressed by the system back in it. Have former felons on the juries. We shouldn't be removing these people from the juries. These are the exact people we want on. In the original juries of England, these people could be on the jury. You could be convicted in the morning and on a jury in the afternoon. We need to go back to that type of system. It needs to be that our criminal justice system reflects us at every stage of the process. And until it does, there's going to be oppression. And we really need to do it from policing. That was my concern. At the public defender, at the district attorney's office, the judges, at every stage, we have to reintegrate everyone back into it. And until we do, it's not going to work. It's going to be broken across the board, in my opinion. To go off this morning's questions, that's my wish. That's my kind of hope, is that, again, we have everyone at every stage equally represented, including not just race, but class, including former convicted felons, people who have a different perspective. We want to sanitize our juries. We want to sanitize everything. And that's just not reality. That's not people. We need to have the full array of all people involved in our criminal justice system. It's just going to remain unjust until we do.
And I'll give you two answers. I'll keep one of them really short. But from the perspective of my presentation on hidden sentences, there's nothing like living your life running into penalties that you didn't know you had over and over again. Being reminded you're a criminal at any moment. You apply for a job that you think you can get, and I don't know, maybe ban the box was successful in your state, but you're actually ineligible for this job and nobody told you that. And so what happens is you go through a whole job application process and find out, oh, the system's against you again. And understanding this system of penalties and then possibly lessening it, making it more effective, making it more sensible, but definitely understanding it. I've talked to countless people, countless ex-offenders, whose biggest problem is that they don't know where the next penalty is going to come from, because nobody warned them. And that creates a really deep kind of distrust. The system's really out to get you at that point, because the system doesn't even care enough to tell you. And that'll lead me to my broader point. We need some trust. We were talking about body cameras earlier. Personally, I don't like body cameras. I don't have a much better idea, so I don't get involved in the debate too much, but body cameras don't create trust. Instead, it's just more control. Now we got to control the other people who we know aren't going to behave right. We've got police and communities that we believe have a problem, and now we believe the police have a problem, and nobody can possibly take responsibility or trust each other because there's just control at every step. I'm not sure that's the right answer. We need something more integrative, something to bring it back together. It's abstract and high, but
I think it's a great question, and it's a kind of a circular problem, at least with respect to the jury, because it turns out that if you serve on a jury, you feel better about the jury system. So if you don't show up and you can't be on a jury, then you can't have that experience. And so I don't know how you do that except to tell people that and hope that they will feel that sense of involvement or the possibility of involvement that will have some power. There's an old cartoon that where the jury summons comes and they say, "Oh, I don't want to go. I'm not going to go. Why should I go?" And then they're told, "Well, you know, you can get a chance to play God with somebody's life." And the response is, "Well, why didn't they say that on the summons?" Right? You know, there are few decisions people make, any of us make, that are as impactful as what we can make on being on a jury. And the notion of leaving it to other people is a disaster. I mean, it's a missed opportunity.
You spoke about collateral consequences. The Howard Law Journal in the Symposium in 2010, the topic was collateral consequences who really face the ties for criminal justice. Do you know if any of the issues addressed in that journal have been solved or addressed today, 5 years later?
So I'm not familiar with, I may have read the articles in the Symposium, but I'm not familiar with them as such. So the movement has made some progress. There's been, the first time since the 60s, there have been some repeals and amendment of hidden sentence laws. There's been new ones passed every year too, though. So I don't really have a good measurement of whether we're making good progress in that sort of way. But well, we were talking about the ban the box movement. We've been talking about repeals of bans on welfare restrictions. And it's been happening. And there's good progress being made. My fear is that because the progress isn't really focused on this notice issue. It's not really focused on making sure everybody knows what this system is. We're approaching it a little bit haphazardly. Everybody knows that there are employment restrictions. I've never met anybody who can actually name them, but they can give examples. And so we'll hit broad things like ban the box. If you all aren't familiar with ban the box, it's the idea that a job application can no longer ask if you have a criminal record. At least most job applications. There are some that are, of course, exempt. And so we've been approaching it a little bit haphazardly because we still don't know a lot about this hidden penal state. And my other fear is that we're now celebrating decarceration. Incarceration rates have dipped for the first time since 1970, I think it is, and we're starting to celebrate that reform is working. And I don't want to quash the celebration because it makes me happy too, but it makes me worried that that's all we're going to do. It makes me worried that the reentry movement will end if we no longer have a prison problem. So I guess the short answer is yeah, there's progress, but not enough. Thank you.
Hi, good afternoon. My name is Tanika. I'm a second-year law student and a member of the Howard Law Journal as well. And my question was, Professor Azevedo mentioned the Truth and Reconciliation Committee and how their work is on Africa and how they can be brought here. But one of my concerns is, I don't know if you thought about this, what agency or what group would be the overseer of such a type of committee?
No, that's a great question. I mean, this goes to, in South Africa, it's of course a national level. Here, that's not going to work. And with federalism and the way policing being local, it's going to have to be at the state level. And again, couldn't be the police. That's the one thing, that's the problem, of course, with civilian oversight boards, is they get stacked with people sympathetic to the police. The Department of Justice is actually incorporating this. After Ferguson, they did something very close. They went and held, I think it was, I want to say 45, it might be 10 this way or that, but 45 community meetings to elicit what people felt the problems were and get stories over times they had been abused. And this is where we get some of these horrific stories of one woman who had a $151 parking violation. She couldn't afford to pay it, mushroomed into thousands of dollars. She served jail time. She still owes 500 and something dollars on the original $100 fine. So it is starting with the Department of Justice, but I think it needs to go beyond that, to be decoupled. But it needs to be wholly independent. I would imagine it would have to be something cities set up, but with an independent commission not attached to either the district attorney's office or the police at all. And we do see these ad hoc type instruments in the US system, and it would have to be something along those lines. Again, it isn't a permanent idea. I would view it more as like the investigative grand jury that some states have implemented, but even not that permanent. It would be much more this one targeted issue, find out what happened to as many people as possible. And again, it then gives them also information that if they want to form a class action suit against the city, they now can. So there's a benefit also to encourage the community to come into it as well. Thank you.
Good afternoon. You spoke a little bit about remedies for police brutality and in situations how these remedies work or don't work for that matter. And you talk about shaping the issue before the courts as an issue of dignity and these people's, these targeted groups, their dignity being compromised. My question is, how do you shape the issue considering that the court is really reluctant to deal with race? And it's really hard to separate the targeted groups of police brutality, their race, from their human dignity. I don't see how you could shape the issue as their dignity without their race. So maybe shedding some light on how to shape it.
Yeah, I fully agree. We're going to have to tackle race. The courts don't like it. Push comes to shove, it's going to have to be done. It isn't always race. So in the paper itself, I looked at 3 police departments, 2 race. In New Orleans, the problem was actually gender and sexual orientation. So, but we are going to have to, and I think, again, that's why I looked at Obergefell, because that kind of was this moment where the court tentatively, hesitantly, reluctantly seems to once again be willing to deal with these issues. But I don't think it can be decoupled. I don't think it should be decoupled. If race was the reason the police degraded someone, race needs to be part of the solution. And until it is, we're just putting the problem off another generation.
All right, with the mushrooming attendance in the last couple of minutes, you'd think the state's attorney from Baltimore was going to be here at 3:15 or something like that. 2 quick things. One, just a couple of days ago, Judge Emmett Sullivan down at the U.S. District Court down the street wrote an opinion with respect to a deferred prosecution agreement for a corporation. And he lamented in very, very, very stern terms that deferred prosecution agreements should be more available to individuals, largely to keep them out of the conviction realm, in which case to avoid the mountains and mountains of very damaging collateral consequences. So that's an interesting thing to keep up. One other thing, a very funny joke that I think is funny about the jury, and then we'll thank everybody. And that is Mr. Boffo, a weird kind of comic strip that I don't think runs anymore. But there was a thing about, blank, unclear on the concept. And there's various things that say weird things. So in one, there's a dozen eggs in an egg carton. The caption is, eggs unclear on the concept. It shows a dozen eggs, and the caption is, one of the eggs is saying, I guess the first thing we have to do is pick a foreman. Okay. Well, listen, thank you very much. Whatever.